Yes, welcome, welcome, welcome. We're very proud to, for the Center for Law Equity and Race Clear to present this conversation for you. We have Faculty Co-Director Berta, who's here with us. And thank you so much for those who are here in person and those of you who are online. So we are joined today by Lisa A. Crooms-Robinson. The title of her presentation is Reconstructed Blackness, Race, Identity, and Belonging in the Life and Work of Pauline Murray. So Professor Groom is the former interim dean of Howard University School of Law. She works in the intersection of law, identity, and rights as matters of both domestic and international law. She is a prolific writer, has authored 23 journal articles and book chapters, and co-authored or edited 3 books. Her most recent publication is Murdering Crooms, Pauline Murray, Intersectionality, and Black Freedom. Currently, she is a Radcliffe Fellow at Harvard and is using the primary sources from Pauline Murray's archive to trace the evolution of Murray's gospel of social justice from jurisprudence to legal theology. So let us welcome Professor Crooms-Robinson and engage in a very interesting conversation. Thank you so much.
Thank you so much. That was so generous. Hey y'all. Hi. I'm gonna say it. First and foremost, thank you, thank you, thank you, thank you, thank you, thank you. I have spent the I'm not complaining. Let me start there. But since August, I have spent a lot of time with Pauli and talking to myself in my head. So thank you for this opportunity for me to try this out and see how it goes. And I encourage you all to listen with kind but critical ears, right? Because at this point, I have fully convinced myself that what it is I'm writing makes absolute sense and will contribute something valuable to, I don't know, the academy, understanding Pauline Murray, these other issues. I could be completely wrong because, as I said, I have spent this time since August, just me and Pauli in my head. Okay, so I think part of what I want to share with you all comes out of the archive, and I have to say, being a Radcliffe Fellow is a great thing. But one of the things that makes it absolutely fantastic is I have the ability to sit in Murray's archive for an entire year. Up to this point, you know, come do a little, I used to call them researchcations, right? You come, you spend a week and go someplace else, do some writing, come back, spend another few days. But the uninterrupted time and access to the archive in Schlesinger, and it is quite an extensive archive. I mean, we're talking over 100 folders and boxes and stuff. I was sharing with Libby. When you keep and carry with you, not store at your parents' house or relative's house, right? But you keep and carry with you things beginning in the late 20s, all the way to the 1980s. A lot of paper. But you can imagine that it not just chronicles the Murray's life, but also captures nuances and contradictions, quite honestly, that if we are all blessed enough to live long enough, we all have them, right? So part of my project is really considering the archives read against what Murray cultivated as her own autobiography, as well as the story of her grandparents, primarily in Proud Shoes. I say all that to say, if you think that those two books have a lot in them, what's there pales in comparison to what the rest of the archive has. The things that Murray is most noted for, right, or the thing at this point, thanks to the late Justice Ginsburg, etc. My name is Pauli, folks, founder. Some of us knew her before, folks found, but just found. I'm glad that other folks have been introduced at this point. But part of what I was looking for, I've been looking at, is not necessarily the work around sex equality and women's equality, whether it's a matter of constitutional equality, or with Murray in particular, looking at Title VII and ensuring that sex was retained as one of the protected classifications. So Rosalind Rosenberg has already done a fantastic job, and it's fairly exhaustive looking at that work. Serena Mayeri has also done an incredible job looking at that work. I was curious to look not at Murray around issues of sex equality, but look at Murray's relationship to race, but more specifically, relationship to Blackness. So I share with you an anecdote from my head, because I told you I've been talking to myself. The Smithsonian is a huge institution with multiple museums. If you do a search of the Smithsonian and put in Pauli Murray, every hit comes up as part of the National Museum of African American History and Culture. I'm not quite sure Pauli Murray would be happy about that. And I say that because depending on the period, Murray is striving, kind of like County Cullen in some ways, to be just American. Full stop, period. No adjective, no hyphen, none of that. So I'm trying to figure out what's going on here. Speaking of County Cullen, I'm trying not to be Langston Hughes, right? I am not prepared to dismiss Murray or read into what Murray has articulated as wanting to be white, right? For those of y'all who don't do Harlem Renaissance literature, County Cullen said he just wanted to be an American poet. Langston Hughes read that as County Cullen wants to be white. And there was this kind of debate that then resurfaces in some ways with Baldwin, earlier Baldwin. The Baldwin that Baraka then took to task until they both got on the same page, which leads Baraka to actually eulogize Baldwin at Baldwin's funeral. But this idea that it's not that Murray is somehow anti-Black or inauthentically Black. Murray's Blackness lines up with a long history of people who their subjective experience is in fact one of being a race individual as interpreted by the larger society and subject to its constraints, even though what they articulated was a desire to live free from those boundaries, free from that identity, the freedom to be able to choose what your identity looks like. And it's interesting, Murray came up with a few words, kind of like early Tiger Woods. You remember combination? Mixty was a word. M-I-X-T-Y. And then there's like a Urindi Afro something. But it's not Black. But that is authentically Black because there is a history ranging from the most extreme version of this would be passing to stuff that's slightly softer, but it's not enough, and I'm not the one to make the judgment. It's not enough for me to then write Murray out of being Black and attribute this desire to be able to move freely in this way as a desire to be white. I'm helped out here by, I like reading the law, but I really like reading stuff that's not the law. So I'm just sharing that with you. Evie Shockley is a poet. She was a lawyer. We were law school classmates, and she was like, the law is not for me. But she's a poet, but she wrote a book called Renegade Poetics, where she looks at the idea of multiple Black aesthetics, that the terms are broad enough to capture anyone who is writing as a Black person in the United States within the aesthetic, regardless of the form in which they write or the subject matter. Because if you show up as Black and you write as Black, regardless of what it is that you write, it's still an expression of you being Black. It's your subjective sort of experience. So you can write sonnets, and that might be a European form of poetry. You may even write sonnets about nature. But the fact that you are a Black person operating in the United States and writing these poems, there's got to be a space to recognize that as Blackness, even if it doesn't line up with what many people would assume is authentically Black. So this is an attempt to expand Black and Blackness within the context of the law to, in fact, accommodate how Murray moved, but also to sort of excavate, using Murray's work, the changes in Murray's relationship to Blackness, Black communities, and Black people. So, when Murray is living in Harlem, starts off at the Harlem YWCA, and among the people who Murray's hanging out with, it's Dorothy Height, it's Ella Baker, it's her friend Maida Springer. Really the only people who are living at the Harlem YWCA. It's this really rich community of Black women. We're Black then, and we're embracing it. We write an entire long-form poem, Dark Testament. The subject matter of that and the voice in that is clearly articulating things from the perspective of a Black person in the United States. Murray comes to Howard to go to law school, and while there meets two women who begin to make her change her view of not just identity, but what could be possible in terms of looking at equality more broadly. One of those women is Carolyn Ware, who was in, I want to say, FDR's administration in the Labor Department, but also was a professor in the history department at Howard. And Rayford Logan, in fact, hires Ware and Mers Tate the same year. Mers Tate was an incredible Black woman historian, and I want to say she might be the first Black woman hired to the faculty in the history department at Howard. The second person is a woman named Betsy Graves Renault. And from what I've been able to find out, Graves Renault was part of the group of suffragettes who ended up being jailed in Occoquan. So she's older, but you all know that Howard is an HBCU. All right, so my point won't be lost. Ironic that the sort of women faculty that Murray finds appealing, right? Mentors, or women who were at Howard at the time as mentors, there are two white women. And then I thought, well, maybe there weren't any Black women. No. There are a whole host of, or way more than the two white women at Howard that don't turn up in anything that Murray's sort of talking about happening while at Howard. There's organizing happening in the undergraduate dorm. So Patricia Roberts Harris is an undergrad student at that point. Gloria Richardson is an undergraduate student at that point. Murray is because the law school still has no housing for law students, right? But Murray is living in what we call the quad with the women students during World War II, which means that the numbers favor the women students far more than the men, because the men generally have been, they're off to war. So I found it interesting and kind of curious that Murray's operating in this very Black female space, but what appears to have had the most impact on Murray while at Howard are some ideas that are coming from Ware and Graves Renault. And one of the key ideas is this idea of sex discrimination and race discrimination as being parallel. Got to give a shout out to the person who this research has turned up as having at least, it seems, articulated the idea first, and that would be Blanche Crozier. Graduated from BU Law School in maybe the early 30s, wrote an article that Murray doesn't find until the 60s, making the case for sex discrimination as being a violation of the Constitution. Crozier doesn't take the path that Graves Renault does. Crozier is not arguing that being a woman, being a white woman in particular, and being enslaved are sufficiently similar, hence that's the basis of the analogy. Crozier is careful to say that the discrimination is similar because as compared to the norm, which remains white, male, able-bodied, under most circumstances, married, property, right? That being a woman and being a person of African descent, they are similarly stigmatized and deemed inferior as relation to the norm. That's Crozier's argument, which I see as being fundamentally different from me. I'm approximating a white married woman right now, right? Mm-hmm. Me, white married woman, feel that the oppression in my personal relationship and the institution of marriage has turned me into a slave. Hence, I should be able to take advantage of the 13th Amendment. or that race and sex are similarly problematic, hence both should be, race and sex discrimination should both be viewed as violating the Constitution. So Crozier makes this argument. Ware and Graves-Renault raise it up to Murray, and Murray's like, okay, I see how those two things could happen and why you would make the comparison. The idea here is, however, that unless you are dealing in, I believe it's hyperbolic geometry, right? Most of us only know about Euclidean geometry, right? Right? Trust me. We're supposed to have learned at some point.
Sure.
Plus Euclidean.
Okay.
And one of the fundamental principles of Euclidean geometry is that parallel lines never intersect. Right? That's why I said hyperbolic geometry recognizes the ability of parallel lines to, in fact, intersect. But none of us are dealing in higher mathematics, right? So we're going to go with the common understanding of parallel. And this is what happens with the analogy. If you go to the analogy based on the idea that these things are in fact parallel, it means that you've constructed it so that they never intersect, which means that you have erased the possibility of Murray as a Black, and let me be clear, all right, I understand, don't come for me about pronouns, don't come for me about characterizations, because there are a lot of things I'm willing to rewrite. What I'm not willing to rewrite is Murray's own words. It is not for me, with 21st century sensibilities and understandings of things, I feel, to take someone else's words where they're quite clear about what it is that they're saying and turn them into something else. Other people have done that. That's not what I'm doing. So I do refer to Murray as either Murray or she, in large part because I'm using Murray's own words. But the other thing is, if you strip Murray of that identity, that being a woman, it means that the work for which Murray is most noted ends up not being sufficiently kind of moored in anything. Most importantly, Murray's own experiences walking through this world, regardless of what Murray might have thought in Murray's head, similar to the Black piece, Murray shows up and Murray presents as not just Black, but as a Black woman. And that's how Murray's experiences with power, law, etc. sort of unfold, which then explains, I think, why Murray was so insistent beginning, I'd say, early 60s, when Murray is appointed to the President's Commission on the Status of Women by JFK. It's chaired, I think, in a more honorary way by Eleanor Roosevelt. That all of that work that gets done is done from a place of advocating for the rights of women specifically. All right, that was an aside. So basically the idea here is I'm looking at Murray's relationship to Blackness in terms of not starting with the Reconstruction Amendments and moving forward. I'm going back to Scott versus Sanford to view the majority opinion in that case as establishing sort of, or stating the definitive legal and constitutional statement about the legal status of Black people and Blackness. My view is if you start there, then the Emancipation Proclamation, 13 and related laws. So I'm not just looking at the Civil Rights Act of 1866, I'm also considering the Freedmen's Bureau Act. And 14, I'll leave 15 to the side for the moment, that all of that movement is in response to what Scott laid out as being the basis to conclude that Blackness, not status, should be the determining factor with respect to Black citizenship and claims. Because, you know, you can read the case and realize it could have been decided with a much shorter opinion that did not sweep as broadly, given the status of the people who came to the table with the claim, right? One could have just said, Northwest Ordinance, unconstitutional, Scott and his family, not free, which means the opinion then is limited to those specific facts. If you've read the opinion, you know it's not that tight. It takes a claim, a freedom suit by individuals whose status is being litigated and changes the importance of status, that being free or enslaved, to something that has little to no bearing on the personhood or citizenship claims of Black people. Does that make sense?
Would you try that one more time?
Sure. Okay. The Scots bring a claim, and their claim is, among other things, we're free. We're free in part because we were moved from slave state to a free state, and it's almost like freedom by movement, manumission by movement. That's a different, that case or that set of facts raises a different issue, I think, than the issue that was ultimately decided. Because the issue that's ultimately decided is, are any Black people, regardless of their status, to be considered part of the people or citizens? Does that make sense? All right, so I say all that to say, Murray's got a relationship with Blackness that, I'll cut to the chase. I believe that Murray had to distance herself from the Blackness at the center of Scott because the work that Murray's most noted for requires you to minimize, if not erase, Blackness as what the 14th Amendment was actually supposed to address. And Murray does an interesting move where Murray changes it from Blackness to arbitrary. That, and if you look at, this is part of what the argument is that's made in White versus Crook. The 1966 case decided by, out of the Middle District of Alabama. But and it's an ACLU case, but it arises out of the SNCC organizing in Lowndes County, Alabama, which, if you know anything about Lowndes County, one of the things that Lowndes County was not at all interested in was immigration, right? Lowndes County wanted self-determination because it's 87 to 89% Black, it's a plurality of Black women. They're like, you can keep the immigration part. We just want to be able to vote, which means we want to be able to sit on juries, which means we want to be able to, as the majority, decide how our community's needs are going to be met here in this particular county. ACLU, with not just Pauli Murray, but Dorothy Kenyon, they come together and they're the ones that push to include sex. Because in Alabama, basically the problem was the juries in Alabama were all white, all male. They were all male because there was an Alabama law that prohibited women from serving on juries, all women. They were all white because of the practice in a place like Lowndes County of using the voter rolls to populate the jury box. And the voter rolls were all white. So the ACLU originally is going to challenge just the practice. But Kenyon and Murray point out, if we challenge the Alabama statute, that puts us in a different procedural posture than just challenging this practice. So they merge the two cases, or the two sets of plaintiffs, right? But it's Lowndes County, Alabama in 1964-5 pick. Part of what the analogy does, the parallel, and this is where the arbitrary piece comes in. The ACLU, with the assistance of Murray and Kenyon, is able to argue that prohibiting women from serving on juries in Alabama is arbitrary, and the record they use to prove how arbitrary it is the record of white women who have served in political and other appointed positions in the state of Alabama. So, I want to say chief judge of the criminal court in Alabama at that point in time, a woman. The superintendent of school in Lowndes County, a woman. Who else? Somebody else. You get the point, right? But remember the year, which means, Governor Wallace's wife, Pauline, right? She runs for governor. Now, it would appear on the women's right side of it, Alabama's got a fairly progressive kind of history here. What I think the ACLU and Murray's part of that group, what they underestimated or ignored, perhaps, was the extent to which the narrative that supported the arbitrariness of sex lifted up women who were fundamentally committed to maintaining white supremacy and white nationalism. Hence, they weren't being called to account for their own racism. Another curious piece of this is the Justice Department claimed that if women, white women, were allowed to serve on juries, it would increase the likelihood of justice being done because the white women on the juries would be more likely to convict Klansmen. I'm having a hard time. I was like, oh, that's interesting. And it's like repeated in different, like the Justice Department memo includes that, then the ACLU memo includes that, and then Murray repeats it independently a couple of times, and it's like, oh, well, that's interesting, but I don't think that's accurate. The other part of Murray's point, and the Justice Department echoes this, is the cases that they use to demonstrate where there might be a more favorable outcome are cases involving Viola Liuzzo and Jonathan Daniels. I'm not saying anybody deserves to die. What I am saying is it's an interesting kind of analysis because what you end up with, the only plaintiffs in this case are, of course, Black women. Because the interracial sort of sisterhood that Murray is wanting, there is no evidence that it exists in the state of Alabama, let alone in Lowndes County. So the Black women who are the plaintiffs end up doing the work to free up white women who remain committed to Jim Crow, white supremacy, white nationalism. And it doesn't necessarily yield any more justice or favorable results in racially charged cases. So that's part of where I kind of started, which has led me to sort of think about why Murray's relationship with Blackness in particular kind of looks the way that it does. And part of it is, in order to do this analogy, you have to remove Blackness and put in arbitrary. Because the case that she relies on is a case that's decided in Texas in 1954. Challenging the exclusion of Mexican Americans from jury duty. Hernandez. And in the Hernandez case, the court, the Supreme Court, says excluding people of Mexican ancestry from juries is arbitrary. I don't disagree that it's arbitrary, but I do think that Murray and others failed to consider how the treatment of, well, first, in Texas at that point, Mexican Americans are only white because Texas couldn't figure out what else to call them, right? So part of the pushback against that case was, well, what you're talking about is ostensibly, according to how Texas defines it, white people discriminating against other white people. But we know that that's not really what was going on in Texas. And the Supreme Court was able to see that here, being Mexican and being Black do the same work as against whiteness in Texas. So, in expanding it to arbitrariness, under the 14th Amendment, Murray sees this opening and is like, okay, we can go with this, because then sex is similarly arbitrary. But I think failed to take into account that the first Anti-Peonage Act is enacted by Congress using its Section 2 authority under the 13th Amendment, and it's a Reconstruction statute, which means what the Hernandez case doesn't account for is the fact that Mexican peonage, enslaving people of African descent, from the beginning of the operation of the 13th Amendment, they're actually in lockstep, right? And we know that once you get to, what is it, are the peonage cases, I think 1911, then there's Bailey versus Alabama, there's that whole line of cases that challenges the idea that forced labor, the forced labor that the 13th Amendment is intended to prohibit, somehow ended with the official abolition of slavery with the 13th Amendment. That these were practices, Mexicans, Chinese laborers, these were things that at the time the 13th Amendment is ratified, there's an understanding that these labor practices are connected enough so that they could all fall within the prohibition found in 13. That's not reflected once you get to Hernandez, but definitely not once you get to Murray and Kenyon's use of Hernandez to then expand 14 to eventually reach sex discrimination. So there are things like it had to shift, or else the blackness was going to prevent you from being able to make the analogy. But there's also this commitment to integration. Murray would call herself an integrationist almost until the end. What that meant, I think it operates at two different levels. One is being able to show up as your fully integrated self. So pushing against people who would limit you, and that goes back to I'm not necessarily Black, but not rejecting race altogether, because Murray reminds me of my late grandfather, Gabriel Crooms, who he was colored until he died. And that was like 1980 something, right? And I remember having a conversation with him, and I said something about African American, and he looked at me like I had lost my mind. He was like, ain't no Africans here, right? In some ways, Murray is of the same generation. And while he preferred colored, but he would do Negro, but it needed to be capitalized. Capital N, Negro, that's what we are. Well, if you're trying to operate in certain places, including Brandeis, right, in the mid to late 60s, as students are on campus, they want Black studies, this whole Black power, Black liberation, Black is beautiful, right? I'm one of those children. That's me, elementary school wise. Murray's like, we're not doing all of this, in part because if I take formal equality to its most logical conclusion, organizing as Black people for the purposes of self-determination and liberation and self-definition is just as bad as Jim Crow. And if I thought that it was bad over here, it's going to be equally bad here. It's definitely formal equality. Those two things they delay Murray's ability to appreciate what's happening on the Black power and Black liberation side. And I think a lot of legal scholars miss that, quite honestly, because everybody wants everything to be civil rights and they don't recognize that they're two different eras and two different movements, looking for two different things. So part of that desire to live as an integrated person in an integrated community is based on the belief that what Brown mandated was not desegregation, but integration. And we know, however many years later, right, that was definitely not the case, that any commitment to integration was merely remedial based on a court order, based on findings of a previous de jure system. And what's the case out of DeKalb County? Franklin? Where they said basically you could achieve unitary status in stages. So it used to be that they'd come up with a court order and they'd have like 6 things that you have to satisfy, and all 6 things would have to be satisfied all at the same time in order for you to be deemed unitary. There's a case out of DeKalb County, Georgia, where the court says, your teacher numbers look good, so we're gonna say you're unitary there. But come back to us with the other 4 things, and then you come back with the next thing and say, okay, that looks good. Now what about the other 3? Well, the other thing we realized was desegregation did not, even integration as a remedy, didn't guarantee the space for school districts to be able to maintain the numbers or the distributions that they saw with once they reach unitary status. So once you reach unitary status, it's like, that's it. You've got nothing else to do, and whatever happens afterwards, it is private choice. It's not the result of de jure. We've seen that in the housing and residential segregation cases, but Murray's not alone. I think a whole lot of people believe that desegregation and integration were the same thing. And that once Brown came around, then we would all be going to school in places that looked like Benetton ads. Right? But the reality was, and if we weren't clear with students, parents involved, because that's when we should have been paying attention, right? If we weren't clear with parents involved, we're very clear post Students for Fair Admissions. And I'm not even going to entertain what has happened over the past 3 weeks, because that's more of the same. So that's basically where I am, what I'm thinking about. And I think the most generous thing that I've been given is I've walked back from, because originally I was like, she seems to be running from black. I just don't understand it. And then I was like, she's not running from blackness. She is performing a particular type of blackness that, if we're going to be honest, has always been there. And blackness has to be broad enough to, in fact, capture the way Murray showed up and the way Murray sort of negotiated all of that. The last little piece I will say, which gets to the end, is Murray's views change in seminary and post-seminary. I don't know if it's because the assessment is different, right? What we're looking for when you're talking about matters of law looks very different than what we're talking about when you're in the theological kind of sacred side of it. But I will also say that J.D. Otis Roberts, who was a theologian and a longtime Howard University School of Divinity faculty member, he presented for Murray a version of Black liberation theology that Murray could embrace. James Cone, Murray found she just wasn't feeling that. But Roberts allowed Murray sort of the grace and the space to be able to see that the work around Black power and Black liberation was a necessary stop if what we were going to get to at the end was fostering relationships between people who come to the table equally yoked in some ways, right? It's not that you're being introduced into some space, you're being invited and you're thankful to be in that space. It's from this position where you've been able to organize collectively, that then the collective is in a different position, is a different power dynamic in terms of how you sort of navigate living in this country with other groups. So you're not going with your hand out or expecting X, Y, and Z. You're coming, you're coming to the table with your people behind you to be able to make the demands that you feel are in the best interest of your, and if you can't strike a deal, then we're gonna go someplace else and figure it out. But it's a necessary step, and Roberts allows her to see that.
You want to take some questions?
Oh, yeah, because clearly I haven't talked to anybody, which means I can talk about this for all afternoon, and all of this that I thought I've spent enough time with it, so I didn't have to do a whole lot of this. But
any questions, comments?
Hi, I'm curious what you think Murray's queerness or perceived queerness had to do with those different constructions of any relationships to race or Blackness specifically.
if I think about that, I wanna say that Murray's relationships in Harlem may in fact be the answer, or an answer to your question, but it's. I don't know how to put this. In looking through Murray's archives, it is possible to construct, and I guess I'm thinking outside of the times when there's like a crisis, right? There's like one huge green diary that I found. And I spent a lot of time going back and forth as to whether I was going to go into those diaries at all, truth be told. There's one huge green diary that gets written in when Murray is in the midst of a crisis. And just writing it out. Some of what you're talking about with respect to queerness does kind of play out there, but I think it's primarily Murray's relationship with Renee Barlow that plays into going to seminary and then finding Robertson that language to be able to look at Blackness and Black self-determination in a different way. I mean, simplistically and anecdotally, see, that's speculating. Because I've got one answer that I would really like to potentially put out there, but it's my own speculation. And that, I'll speculate, is Murray's romantic desires appear to only be directed at white women. And that, I think, plays into how Murray performs Blackness as well as the extent to which Murray is willing to embrace Blackness. Imagining this interracial sisterhood that exists out there somewhere, I think, from what I can tell, it has less to do with time spent, let's say, at Hunter, right, which at that time was a women's college, and more to do with Murray's personal relationships. But that's me speculating. Yeah, that's me speculating.
Other questions, comments?
None. Thank you. I knew there was a question in here somewhere.
Yeah, so I was just wondering, do you think that is the word universalism like an appropriate word to, am I understanding correctly your perceptions? And then secondarily, how, if so, like how much is that tied to the sort of parallel analogy that you gave us, with so that so that we could say maybe that universalism is sort of is born of a kind of intersectional failure, right? A kind of like a kind of the sort of her hopes kind of being dashed.
I think that the universalism is actually there even before the idea or the terminology around being because Murray is at Cal doing LLM work around the same time that the UN is being founded, right, across the bay. So I think that a universalism language, right, that we see a lot of in human rights begins to, well, is there in Murray's sort of thoughts as well as the work as early as 1945, 1946. Even if it's not fully articulated until, I want to say it's like around 1966, 67, Murray gets a contract with, I think it's the United Methodist Women, and writes a pamphlet, basically, Human Rights USA, where Murray is advancing in ways that a lot of folks hadn't necessarily begun to even really think about human rights. Murray is advancing a human rights analysis as applied domestically to the United States. So I think, I'm hoping I'm answering your question. I think that the universalism, the inclination for universalism starts as early as the 40s. And Murray just finds more and more places to sort of riff, as it were, on it, and just sort of plant seeds, and we'll see where it brings up. But as you know, both and,
Yeah,
right?
yeah.
So the universalism doesn't mean that you necessarily use that instead of what might be the individual piece of it. But there's gotta be space for both to be able to
Right.
sort of operate and be reflected in the broader kind of legal principles, perhaps.
Do you find any hostility toward men in her writings?
Interesting. Hostility towards men. Some. She couldn't stand Adam Clayton Powell. Her feelings about Martin Luther King, like, go back and forth. Like, she digs King for nonviolence, but on more than one occasion, she got problems with King for the way that Rosa Parks was sort of situated in Montgomery, and the fact that the Big Six was just that until Dorothy Height got sort of invited. She is not feeling SNCC, Lowndes County, and be at all. Attended at least one of the Black Power conferences and was like, oh no, this is crazy. But interestingly, like, I'm going through the stuff and Baldwin. Interesting kind of thing, because she and Baldwin are at McDowell together. She's working on Proud Shoes. Baldwin is working on Giovanni's work. They are the first two Black folks to do the residency at McDowell. There is no evidence of them having anything to do with each other. In part because she's older at that point, right? It's a generational thing.
Yeah.
And I think that she's looking at Baldwin like, well, what's going on here? And perhaps being kind of jealous because Baldwin is free and himself all the time, right? In ways that Murray, I don't think, could be. But after he wrote The Fire Next Time, there's correspondence with, I think she was dealing with Beacon Press at that point. She's trying to pitch a collection of prose, unpublished. And the letter makes the case for, she wrote an essay called American Credo. American Credo being sort of the nut of this larger compilation. And I've read American Credo, and I've read The Fire Next Time. Mary thought that one, Baldwin wasn't saying anything that she hadn't said before. And two, she might have said it better than Baldwin. And I was like, I don't know if I can go there with you, but okay. So she had a little something with Baldwin, but she also had in her own private, she's got like subject matter files and subject matter, and sometimes it's people. She's reading Baraka. She's not reading Leroy Jones. She's reading Baraka, which I found interesting. And it's Baraka has a poem about the blood that is in him. And the end, basically it's like, I've got all of this stuff in me, clearly. I'm Black in the United States, necessarily. He said, but what he would like to do is excise the white and just keep what he would consider to be the good parts. Murray has this poem in a file. And I'm like, Baraka. That's very, very interesting. But she had no words for Kwame Ture. None of them SNCC people, none of the SNCC men in particular. She wasn't feeling that at all. She got nothing to say about the Black Panthers.
We're gonna take one more question.
I have a question as much as a comment. So this has been enormously rich. We're somewhat at a disadvantage because there are people in the room who don't really kind of know Pauli Murray, don't know know the name, of course, but obviously your work is going to be critically important in restoring her and lifting her up in ways that we haven't seen before. But a lot of people don't. When was she born? When did she die? What did she do? What did she do as a lawyer? I mean, so it's just kind of the basics, I think. But so yeah, and on the Baraka thing, of course, the archives can be deceiving. You could have a Christmas card from somebody you never met before, or you could, somebody else could have
Put it in there. Yeah.
So, so just that is kind of a bit of a caution. But for me, I think what's most promising about this project is there are not a lot of early women lawyers out there, 20th century figures who basically, who were trained in law, she was trained in other things as well, but who were trained in law and then sort of figured out, okay, how am I going to use this? What am I going to do with it? And so there's, the Baker Motley biography, which comes a little later on. But Pauli Murray is kind of one of the first of the mid-20th century who's got this training and she's out there and she's using it. And so trying to think about, okay, what does she actually do with it? But also thinking about she's doing a lot of other things. Now, is that because the doors are not open for her and available for her to, use her legal training in ways that, are driven by and inspired by what it is she wants to accomplish in the world as they are later on?
Right.
Is she a poet? Is she is she writing fiction? Is she writing, biography, her own biography, that kind of thing? Is she going to divinity school? Just because she's still searching for this to figure out a space for this huge, vision about what she can do with, what's out there for her. So just trying to grapple with that, like, or is she making choices that are independent of and not associated with what her potential for just kind of in the legal field, which, so is she like a Paul Robeson figure, also trained in law, but then decides because, there's no future for him there, he's got to, find his future somewhere else. So I think sort of grappling and, dealing with that in some ways, I think would really be helpful. And then, and then similarly situating her views about, how to live a Black life. It's unavoidable. If you got the melanin, it's unavoidable, right? But how am I going to live this Black life in this world. Sort of also situating that, in the context of law, I think would be like a huge just a huge contribution to this literature in some way. So this is just enormously, really looking forward to it. It's good. I assume this is a book project, right?
Yeah.
Yeah. So just sort of really looking forward to it, and
Thank you,
Yeah.
thank you. I was gonna say the piece about Murray as a lawyer. Because I agree, in part, the reason why I got this project long ago, J. Clay Smith, who was my colleague, who still is. I don't know anybody who does work around a Black lawyer the way that Clay did. And Clay wrote a book, Rebels in Law, the history of Black women lawyers. And Clay came down to my office and said, "You're a feminist, aren't you?" I said, "Yes, sir." He said, "This is who you ought to be writing about. Pauli Murray. That's who you are." And he just left, right? At Murray's graduation from Howard, Mordecai Wyatt Johnson gave a commencement speech and told the graduates, take your degrees, go south, and work to better the conditions in which the vast majority of our people live. Murray wasn't going south.
now it's county. Put that aside for a moment.
Right. Murray was like, I'm not going, based on experiences from having lived in Durham, what happened in Virginia. She's just not feeling the South. Let's go, she graduates in 44. 20 years later, give or take a year, Murray wants to be the chair of the EEOC. They offer Murray the general counsel position. And although she closed down her law office a number of times while working in New York, it was that moment when Murray had to grapple with, she had to ask herself, do I have the skills necessary to be able to do this job? I have the skills and the mind and the vision and all the rest of that to be the chair, right? But can I be the lawyer? And Murray concluded, no. I don't have the skills to be the lawyer. In part because I didn't follow Mordecai Wyatt Johnson's directive in 1944. Because had I gone that route, it's more likely that I would have been the kind of civil rights lawyer or litigator that I always thought I was going to be. But she got caught up at Howard in, there used to be two different tracks. If you did well enough at Howard, as Murray did, graduated first in the class, you get a Rosenwald fellowship and you go to Harvard. That's what happened to Hasty. That's what happened because Charles Hamilton Houston had in fact created this link, having come from Harvard, so that the person who's top of the class, Howard Law School, automatically goes to Harvard. It's sticks when Murray is the top of the class because Harvard's not accepting women yet.
All right. We're gonna have to get to the class.
Oh, sorry. Sorry.